The Companies Act 1956, Section 43A, private company to become public company in certain cases. So provisions of Section 43A were explaining about the cases, situations where private company were to become public company by virtue of Section 43A, by the provisions of Section 43A. But in section but by the Companies Amendment Act 2000, nothing in this section, means section 43A, nothing in this section 43A shall apply on or after the commencement of the Companies Amendment Act 2000. This Companies Amendment Act 2000 is effective from December 13, 2000. So by the commencement of the Companies Amendment Act 2000, section 43A provisions shall not apply. Even then, we may have some interest. What were the provisions of section 43A? Why certain private companies were becoming public companies by virtue of the provisions? What were those provisions? Let us focus some attention to understand about those provisions. Subsection 1 of section 43A, save as otherwise provided in this section, where not less than 25% of the paid-up share capital of a private company having a share capital is held by one or more bodies corporate. In such situation, the private company shall, on or from the date on which the aforesaid percentage is first held by such body corporate or bodies corporate, the private company shall become, by virtue of this section, a public company. Here we come across a condition where 25% of the paid up share capital, if it is held by body corporate or bodies corporate, from the date onwards, such a private company shall become, by virtue of this section, a public company. There is another condition. This subsection 1 of section 43A carries the another condition or another situation where a private company shall become public company. Let us understand where the aforesaid percentage, means this 25%, has been first so held before the commencement of the Companies Amendment Act 1960, on and from the expiry of the period of 3 months from the date of such commencement, unless within the period the aforesaid percentage is reduced below 25% of the paid-up share capital of the private company, such a private company become, by virtue of this section, a public company. So after the Companies Act 1956, there was another act, Companies Amendment Act 1960. So before the commencement of the Companies Amendment Act 1960, if there were private companies of which paid up share capital was held more than 25% by the body corporate or bodies corporate, in such a situation, within 3 months from the commencement of the Companies Amendment Act 1960, if it was not reduced, then such private company shall become public company by virtue of this section. There are some provisos to this subsection 1 of section 43A, provided that even after the private company has so become a public company. So earlier we come across two conditions where private companies become public company by virtue of subsection 1 of section 43A. So regarding it, there is a proviso, provided that even after the private company has so become a public company, its articles of association may include provisions relating to the matters specified in clause 3 of subsection 1 of section 3, and the number of its members may be or may at any time be reduced below 7. So naturally you may get this doubt when in above said two conditions private companies become public company by the virtue of section 43A subsection 1. What would be the position of the articles? So articles of association of a private company may carry the very provisions even private company becomes public company by virtue of this section. There is another provision provided further that in computing the aforesaid percentage, account shall not be taken of any share in the private company held by a banking company, if but only if the following conditions are satisfied in respect of such share. See, we were referring about 25% percentage of paid up share capital if it is held by some other body corporate or bodies corporate. This underline 25 percentage, more than 25 percentage of paid up share capital of a private company being held by body corporate or bodies corporate. Here underline the term 25 percentage. Regarding it, this second proviso is coming forward to explain us what it should contain, what it should not contain. It is telling us that they provided further that in computing the aforesaid percentage, underline aforesaid percentage, account shall not be taken of any share in the private company held by a banking company, if but only if the following conditions are satisfied in respect of such share, namely that the share forms part of the subject matter of a trust. Such share forms part of the such subject matter of a trust. Second, that share has not been set apart for the benefit of any body corporate, and that share is held by the banking company either as a trustee of the trust or in its own name on behalf of a trustee of the trust. There is another condition that the share forms part of the estate of a deceased person, that the share has not been bequeathed by the deceased person by his will to any body corporate, and that share is held by the banking company either an executor or administrator of the deceased person or in its own name on behalf of an executor or administrator of the deceased person, and on behalf of an executor or sorry, and the registrar may, for the purpose of satisfying himself that any share is held in a private company by a banking company as aforesaid, call for it at any time from the banking company such books and papers as he considers necessary. So, two provisos, subsection 1 of section 43A carry. So, taking into consideration both provisos, section 43A subsection 1 applies and where private companies become public company. Whereas we need to recollect very important point by subsection 11 inserted in section 43A. This subsection 11 and subsection 2A both were inserted by the Companies Amendment Act 2000. Subsection 11 recently inserted by the Companies Amendment Act 2000 says nothing in this section 43A shall apply on or after the commencement of the Companies Amendment Act 2000. Always we need to recollect.